37 of 62.
I get it. Okay, I got it.
Skip.
Yeah, we
to the
live.
next analysis, which is
Live and direct.
I
ain't fucking
it's on
around.
page 39 of 62, the very bottom right.
Okay.
Danger of unfair prejudice.
Ain't not fucking around, y'all.
And then what I was just discussing when we stopped is on page 43 of 62.
Young
And that's
Thugger
exactly
case
where
is live and direct. Is live right now.
What I said that I'd like you to specific this, and that's when you said, "Show me the case." Show me the case.
Yeah, I've taken a look at Williams before because when you gave this to me already, you gave this.
Blow it
I
up.
think that the issue in Williams was well, some different facts, and your expert, was testifying to this particular agent's experience or lack thereof in interpreting rap lyrics. So that's
we're trying to see, can it be used in a court?
The other thing is the lyrics are heard differently based on the listener. I do remember that. The lyrics do not mirror or exhibit an unmistakable factual connection to the charged crime. So that's something that when I mentioned that nexus or other things that the state has to be able to prove. So
right.
It's
Man, this Young Thugger case, this shit right now. This shit going on right now, y'all. We ain't fucking around. Roll one, light one for Jeffrey, man. Light one for that nigga Jeffrey. Put one in the air. This is live. Look at the clock right now. It's live. We ain't fucking around. I ain't fucking around, y'all. Sorry the way the camera's set up, but you know. You know, it is what it is, y'all.
Around to everybody.
This is alive.
You emailed it. Me too. Send me both.
A Young Thugger going back. He going back to cell later on at night. Like, what this suck? How you got court 9 at night? I can't imagine how this. I can't imagine how this Dolph Jones been.
These lyrics was not known. Government wanted to use the lyrics as the defense confessions of charged crime. That's lyrically inflammatory. There's great lyrics that jury was.
So they trying to use certain lyrics that Young Thug that a crime occurred.
Professor Nielsen had potential to become a feature of the trial and overshadow the acts and give rise to the charges. And so they didn't think that this particular testimony was helpful to the jury. They thought it could be the judge wrote confusing and misleading to the jury.
That's 403.
Mm-hmm.
Said in their proffer, Your Honor. Two.
Oh, I got proffers.
According to the party, they have recordings with Mr. Eppinger, telling people to ask whether Mr. Williams approves the killing of Mr. Bennett. They have recordings of Mr. Myrick about killing Mr. Bennett and asking Mr. Williams for permission.
I don't know who Mr. Bennett is. Mr. Bennett is YFN Lucci.
Time on these videos and lyrics, and that is of the case United States versus Williams that we're discussing, and it's on page 43 of 62, and the court excluded the lyrics and the rap songs and the video.
See, it's certain songs, Thugger. It's certain songs, Thugger, was you saying his name.
That are lined up in Mr. Williams' case, and when I say that,
certain John, they said I shoot at your mama house.
where we don't know,
I come out the Waffle House, like shit like that. Like,
and what it applies to, and it's generic, not specific, going back to the Second Circuit case of United States versus Carpenter that we discussed earlier for the state side.
sorry for the connection, y'all. Sorry for the connection. It's
It will add great delay. When we have a trial introduced, these are a lot of lyrics. That means songs. We have two experts on this. If to try, there's no, it's going to be a year. That is going to be a substantial part of the year. So I ask you to evaluate it. If it even comes in, if it even gets through First Amendment protection process as well. And that's what they did in the Williams case. That's why I gave it to you. And that was decided, as you said, December 9th, 2022, and then adopted by the district court. The next one, Your Honor, and it was emailed to you, I believe, by the Honorable Doug Weinstein. I asked him to, and I thank him. And that's Commonwealth of Massachusetts versus Gary, or Gray, Gray. I apologize. And that is 978 Northeast 2D 43, 2000 Supreme Judicial Court of Massachusetts. And what the court on your...
This is live and direct.
Okay. And this is in...
I'm not fucking around. Like I told y'all, this courtroom is now, like it's going on now.
Let me get the exact page from the email, because the email is going to be different than... Okay. This will be, it's Division 3, and that should be on page... Let's see.
Is that the rap video?
Exactly.
So it's gonna be so basically.
And what the court
So basically, the feds trying
well,
to use certain shit.
Let me see here. To the paragraph.
See, they're not trying to use everything as certain songs.
Direct statements. So let me find the page.
So the thing about it is they kind of sort of use the lyrics in A.R. Absent situation. So I can't imagine what they're going to do to Jeffrey.
Okay, it should be
We got Rollo home.
on page 15.
Rollo home watching this shit live.
There was no issue as to gang affiliation. In fact, the defendant was willing to stipulate to it.
Well, what they wrote.
Willing to stipulate to it, and the court, said, it shouldn't have been admitted because it was minimally, if at all, probative and highly prejudicial.
This is live and direct.
And basically, it said here that evidence that poses a risk of unfair prejudice need always be admitted simply because the defendant has opened the door as to his admission. The judge still needs to weigh the probative value and risk of unfair prejudice in terms of balance
on the lyrics.
Admission. So that's consistent with our law.
Okay, and then on page 16, with the state saying
these are all
their gang expert.
These are all
it is
that's a police officer.
Yep.
Who's qualified as the expert without more.
Yep.
Okay.
Cannot without more be deemed an expert qualified to interpret the meaning of rap music lyrics. So that's why, again, I don't believe that the state.
How the hell is these niggas experts and these niggas ain't rappers?
And then the last case for
So what
now,
they
I'd
got
like you
higher
to
up
see,
rappers
is
doing this
also
shit?
recent. This was decided October 20th, 2023. It was emailed to you. And that's the Honorable Doug Weinstein. God bless you.
Damn,
United States versus Donald, D-O-N-A-L-D.
that sneeze was hard as shit.
And that is, I have it, sir. 2023 Westlaw 6958797. And this is the Western District of Connecticut. It was just decided. And I have to find out where in the email. But it's in Division 6 Rap, Music, Lyrics, and Video.
Mm-hmm.
And let me just find that.
This work in his favor. If this work in his favor tonight, that's gonna be the best part about the case. It's gonna be the best part of the case if he get it. If he get that drop. Yeah, man.
It's on page 20 of 32. It's Division 6 Rap, Music, Lyrics, and Video. I got it. And then
Like
on
they got all these.
2, 3, 4, 5, 6, 7. It's actually on the next page.
Oh,
7. It's on the next
the
page.
judge said this should have
third
take a
paragraph.
year.
So it's on page 21 of 32. It starts with
We
the
go
issue
through
of
all his
prejudice.
songs.
It doesn't tell me anything that George doesn't tell me.
Well, I think it answered your question earlier. You said, what's the prejudice? The issue of prejudice with respect to the...
No, I didn't say that, Mr. Steele.
Damn.
So you said that...
I did not say that.
Okay, no,
I understand what I need to do in terms of prejudice prong. Okay? Under 403.
He
I
put,
get it.
put
Okay.
words in
I
his
don't
mouth.
need any other cases from any other jurisdictions. We have plenty in the state of Georgia, which give me a lot of information on how I'm to interpret that in terms of legal relevance.
okay. I just like to highlight this.
Mr. Steele, please, let's move on to something else, okay? I don't need to cover 403, all right?
But I think but under 403, that's
He
what I'm
not
trying to say.
trying to get
It's
it.
so prejudicial. It's just so, this
Told me
gonna,
that at least 10 times already. Okay? I get it.
okay.
That, so tell me something
Something
else
else.
that I can use in order to determine whether or not it's a threshold issue. I'm going to allow this.
All right. So next, if you don't mind, and it was emailed to you as well, you should see, and it was emailed to the state earlier today. You should see, it's entitled State of Georgia versus Mr. Jeffrey Williams. And what I did was
Versus Mr. Jeffrey Williams.
go
How you
through
say,
what the state gave me. So I took the indictment and their motion. And what they said was the relevant information. That they wanted to get it from the lyrics or videos. And I marked it, it's the same thing I emailed. Mr. Williams, number 3. May I approach you on?
So I gave you permission to move on forward.
It's the thumb drive, but it's what I sent to everybody. I sent it to prosecutors earlier today and the court just now. And
I'll consider, it'll be considered under 104 analysis.
so the first lyric, and you could read this yourself, but this is pretty spelled out, and with the court's permission,
You got four. It's a, for lack of a better word, just a chart. It's got the lyrics and the reference, a song and an album, the artist, and the video clip and YouTube timestamp on it, and a link to there.
This shit's serious.
Going from references from capo to big dog assist to wed rings and red bottoms to snitches, kill you, shoot up, clean kills, switches on our blocks, smoke you like a blunt, hose setup, drug reference, bodies on bodies, murderous wet blood, pistol gun, red bandana, head honcho, FN's Chappas, that's Charlie Hotel, Oscar Papa Alpha Sierra, King Cobra, I'm the principal, boss, perfect leader, serve codeine, shoot you, anti-police, mixed red and green, syrup reference, not gang reference, run from police, killing cops, mob ties, red like Elmo, wipe a nigga nose. Never killed anybody, but I got something to do with that body.
But I got something to do with that body.
Shot his molly, give the lawyer $2 million, throw your setup.
I'll shoot at your mama's house.
These are the lyrics
that they try to use.
So I spelled them out for you and the parties. I took them from the state's motion and indictment. And the first one is from the motion, and it's number 1. And the lyric is, I was a capo in the hood way before a plaque or a mention. And we gave you, as you said, you could just click on it, the YouTube site for the video so you could see it yourself.
Okay.
But then I gave you how common these words are, this theme is. And if with Miss Edwards' permission, if she can share the screen, Your Honor. Okay, the Zoom link ended. But Your Honor, if you just take some time and look at it, which I know you do. But the next one, underneath where I have the first one of Jeffrey Williams, and I quoted the
lyric
that the state wants, is Capo. It's El Capo album, Jim Jones. And if you click on it, you will see
it's a leader.
That other artist says this.
He called himself
the next
that.
one I quoted, feeling like Jim Jones, N, I'm Capo. Money Man did that. Next one, my other Capo is in big A blank S conglomerate called Death Row Snoop Mother blank Dog. That's Toss It by Tupac. The next one is Capo Head Honcho on the song and the album Phoenix by A$AP Rocky.
Okay, but what does that have to do with, the state's not going to show me all these, or it's not going to hopefully show the jury, and hopefully you're not, these other particular songs, because they're not really relevant for the matter in question.
Aren't they?
Say again?
Aren't they though?
They're not.
The state is saying, Your Honor, these words are so particularized that they go to this crime.
No, they don't. You have to look at them in context, and you're also looking at it from the sense of whether or not Jeffrey Williams authored this, or and the other circumstances that go along with it.
Don't you think it's relevant that calling yourself a capo, the state stood up here earlier today and said, I was a capo in the hood way before a plaque or a mention, and that means that it's organized crime. You heard all that.
Well, capo common meaning. They certainly can mean the head or leader. And that depends on what a jury decides to give it in terms of meaning.
But if it's so prevalent in this industry, that's what I'm showing you. I'm showing you that it's sung about the same type of topic.
But the state's trying to say that it might go to Mr. Williams either being a leader of the
gang.
And if he's singing or rapping that I'm a capo in the hood, that might be something that a jury might find relevant to show whether or not he's actually the leader or not.
Exactly.
They don't have to, but it's relevant for that particular purpose.
But I'm going
Exactly.
to show that every single other person who sings about that is common.
But they're not charged.
But they're
with
not charged with the
indictment.
case.
So it wouldn't be relevant.
So
for that
why wouldn't they
particular-
be? Why aren't
These are
they?
not like, oh my gosh, you nailed the. I'm just using Donovan Thomas. You nailed the shooting. He was shot from a drive-by on Saturday, the 10th day of January 2015, on near Northside Drive in Atlanta. That's particular.
Okay, but capo may be a word that Mr. If Mr. Williams is artist, okay, or it
He calling
that
himself
he
a
uses
boss.
in this particular song. I mean, so and whether or not it has the meaning that would be relevant for admissible purposes in this case is a separate issue.
But doesn't it mean something under the First Amendment analysis that a lot of people sing about that topic
Mm-hmm.
in the
No,
same?
he's using a word. I mean,
All these people using the word.
he's using a word,
All these people that I told
Use
you
a
are
word.
using the same word.
but they're not charged in indictment in count one.
Exactly.
By Arthur.
That's the point.
Right.
But that's not that's not the point. The point
That is the
whether or
point.
not- whether or not it's useful to show membership or leadership.
It's useful to show.
And you're taking it out of context.
No.
You're taking it out of context
How's that?
because you're pulling one word in a particular sentence that has 1, 2,
Try to
3,
make it
4,
say
5,
all.
6, 7, 8, 9, 10, 11, 12, 13 words in that sentence.
That's what the state did. They
No,
they
they
out
put
the word.
They're putting the sentence in terms
That
of
Jeffrey
context.
used.
You're pulling out the word capo and you're saying, well, everybody else is rapping about capo or singing about capo.
Mm-hmm.
So that's protected speech.
None of those other words matter. If
Okay.
I was a capo in the hood
Way before a plot, though.
black or a mention, they're using it because I'm saying I'm a leader.
Mr. Steele, I will give you that other people may utilize words that
Don't mean
that
nothing.
you or somebody that somebody else may also use in those songs. I'll give you that. But whether or not they're admissible or whether or not they go to a particular purpose, that's another thing. So
I don't.
that's for the jury to. If it's admissible as a threshold matter, the jury's going to have to decide whether or not, like in the first one, capo, whether or not that is attributable to your client being the leader or in a leadership position or singing about that. Hey, I am the head of this particular entity.
But Your Honor,
That's-
I go
So
back.
that would be.
But is that word
that's definitely
capo?
relevant in terms of in terms of what now whether or not the jury decides that
It's
is
that
another
word
thing.
I don't want to go
capo.
to the jury.
I know you don't
I
want
want
it to,
you
but
to.
it may. I mean, it might.
I want you to exclude it because
I'm probably not going to exclude that one. I'm just going to tell you that because that goes to for a number of reasons.
Uh-huh.
It can go to show whether or not, as Ms. Hilton pointed out earlier,
Is
about
he the
4 hours
leader or
ago,
not?
whether or not your client actually is the leader of this
Mm-hmm.
particular gang. Now, that's assuming also that we have attribution, authorship, and a foundation can be laid.
how about the First Amendment?
I don't believe the First Amendment is going to cover that one.
Wow.
It's so unparticularized, and that's the whole point.
Okay, Mr. Steele, again, they got to be able to lay the foundation. If they lay the foundation, I'm telling you that particular one would be admissible.
Well, I don't know how it gets through the First Amendment when all these other people are singing about it, but I respect this honorable court. But that's what all this is. All
All
of
this is
Your
hearsay.
Honor, and
And D3 is for my consideration, but but in each one of those categories that the court read off, and that you have listed other songs about that or other references. Like I said, I'm not saying that other people haven't rapped or sang or written about those particular lyrics, and and those particular individuals, they're not charged or referenced in this particular indictment.
but their lyrics shouldn't be used against them.
Well, it depends on the purpose. Again,
You just have a lyric. A
Right.
common
no,
everyday lyric.
they're not punishing or seeking to punish or seeking to
Over a
introduce
word.
and criminalize your client's if it is your client's artistic product under the First Amendment. They're not trying to do that.
I think they
You
are.
basically
and,
are.
and that has been the assertion by several folks that's what's going on. I'll admit or exclude this particular evidence based on the rules of evidence, not because it's going to be, First Amendment's on trial. If it does fall within the First Amendment, then I'll apply
How
particular
do
analysis.
it though?
If it doesn't, then I will look at whether or not it falls under the actus reus, mens reus, logical relevance, other offenses, 402, any of the 24-8, 801D2A, 801D2B, 801D2E, 24-8-804B3, and the intrinsic and the other statutes under 1615.3, 1615.9. And the last thing I will do is determine under 24-4-403 the legal relevance. And if it meets all those gates or the gates that are applicable to that particular statement, I will admit it. If it fails, I will exclude it.
All right. Well, I'm just going to then stop in place because I hear you clearly. I'd like you to
They
look at
know
one
this
note,
is
if you
what
don't
the
mind, on
case
that
is over
same
about.
email. If you could just turn to page.
What
8.
page of D3, sir?
It should be 18. It's number 21, boss.
Hold on. 18 of 23, page 18?
It says 18 on the bottom of my copy.
Yes, sir. 20, and it's 20. It's the 21st reference to boss.
And the lyric that the prosecution wants to put in is, quote, I'm a
Capo.
boss. I call the shots. If
Okay.
you allow that in, Rick Ross on the song Boss
I'm a
said,
boss.
I'm the biggest boss that you've seen thus far. Meek Mill on I'm a Boss said, I'm a boss. Bodak Yellow, Cardi B, the artist, said, I'm a boss, you a worker. This goes on and on. What I'm trying to...
Okay, but again, they're not charged with anything in this particular indictment.
So is it that the First Amendment steps aside when a person's charged?
No, but it's contextual and it's fact specific, and it depends upon what they're trying to link it to. We're not bringing Rick Ross, Cardi B, Young M.A., Meek Mill, or Drake, or Post Malone in here to talk about any of those things, or they're not charged in this particular indictment. They sang about being a boss. If the state is trying to assert the reference, I'm a boss, I call the shots, goes to a leadership issue, or I'm the leader of the gang,
Then that's a
then
problem.
that might be relevant. But whether or not the jury decides to take that for the assertion and argument that they're making, that the state is making, is another thing. I am sure that you will probably examine or also make reference to these other particular artists, and whether or not they being the jury
Do they mean it?
finds that this is relevant for that particular purpose. Remember, we're not just saying, hey, Jeffrey Williams wrote about being a boss. That's not what the state's doing. They're saying that they're introducing this particular lyric for the assertion that Jeffrey Williams is the leader
Calling
of
herself
this
a
particular
boss.
entity. Now, whether or not they being the fact finder, the jury decides that they wish to make that conclusion, they'll make that conclusion only after, if I admit the testimony and then I give them an instruction on how they're to continue the facts and the evidence they determine them to be, and they decide that, yeah, based on that, as part of the totality of everything that they've heard, beyond a reasonable doubt, then certainly they can come to that conclusion. They may decide, hey, no, he's not the boss. Just wrote a song about it. But the state's going to present other evidence, and whether or not that individual collectively shows that your client is the potential leader of this particular entity, that's for the jury to decide.
Well, under that analysis than if Rick Ross is charged with being a leader of a criminal street gang, then his lyric comes in.
Well, no, not necessarily. It only if it's for a particularized purpose.
If the prosecution said he's the leader of the gang and that's what he said, then it's
Well,
coming
if
in.
he says also, it might be an admission saying, "Hey, I'm the boss of this gang." They can consider it in terms of. They could consider it in terms of that. I mean, so.
But if you think that through what you just said, and I respect it, Your Honor, but then everybody who in this
All bets are off.
is performing music and saying those words can be used in a criminal case.
I don't think. I mean, you're gonna have your opinion on that, Mr. Steele. I'm bound by what's been presented in this case. I certainly can't give you my personal opinions on it, but but in terms of the states, I'm laughing because we're being timed out on a lot of stuff that my computer just decided to want to restart. So, so what I'm saying is that as much as you think that they're trying to criminalize or they're trying to admit statements that would be otherwise that may be classified as free speech, it's the analysis has to be one or the other. So if assuming that that's it, then the jury will consider that for whatever reason that it's introduced. I'm just not going to let them introduce something just for shucks and giggles on that, just because your client wrote a song about that particular issue. It has to go to a particular purpose. My gatekeeping function is I'm required to do this. They're going to have to present the foundation as to it, and it has to go to an issue that they issue a proof that they have to at trial. They're not. I don't believe they're trying to say that because your clients wrote this song that he's a bad person or anything like that.
So why?
The
thing about it is, why is y'all using rap lyrics then?
Sometimes, as you know, being an advocate, I do have to balance the 403 and legal relevance over prejudice, and that's one of the the harder things I end up having to do as a jurist, but I got to do it. So. But the truth, it is. And then finally, Your Honor, I'll move for the admission of Mr. Williams, number 4 dated today, declaration.
James Hart doing all type of shit.
And you've heard from him before, and that's his declaration. I've already served it on the prosecution
On November 3rd of 2023. Your Honor, if I did not move for the admission for purposes of this hearing of any of my exhibits,
I've already considered D1, I should say D1, which is Mr. Weinstein's, and you have D2 and this is D. Yeah, D2 is the book.
He trying to get them lyrics out the court.
Is the chart on the thumb drive. This would be D4.
Your Honor, I would have more, but I hear the tenor.
They use it so thugger. They use it on ARF. They gonna use it on everybody.
So I will be objecting, and I don't believe the state met any of its burden that it did have to introduce these lyrics. I asked them all to be
crazy part. They're already giving it out.
Mr. Carlson, Mr.
We kind of segmented this. Are they adopted by Mr. Stillwell?
Unless you want to be excluded, I'm going to include them for everybody who they may be applicable to. All right, Mr. Carlson or Mr. Floyd?
It'll be strictly Mr. Carlson.
All right, Mr. Carlson, while you wrap your thoughts around this, I want you to kind of address a couple of different issues. So if you want to write these down for me, just so that you encapsulate them in your argument. These are things that Mr. Steele brought up. In terms of the YSL and the protected speech issue, the chart that you gave me in states 19, that the First Amendment cases, do they apply that he cited to me? Do I have to first consider them under a First Amendment analysis?
Which ones? Yeah.
Second is if you could readdress Carpenter, case Carpenter specifically, and thirdly is the propensity argument that Mr. Steele made, and four is is related to one in terms of protected speech. In terms of proof of who authored these songs or the song lyrics you're going to seek to admit. And then I got two more things, not too much. Under 24/7 704B with expert testimony and the ultimate issue, mental state, could you distinguish that for me or for us?
He really trying. You know that's a major part of the case. The judge know that.
You wanted the last thing would be Mr. Steele's under D3, the chart and the commonality of some of the words that he has mentioned to me related to in terms of these lyrics, whether or not they've been changed or edited.
May I start with the final one, Your Honor? Commonality issue.
Yes, you can, sir.
And if I miss any of them, I'll run through at the end. And I know the hour's late, and I'll.
Anyway, no, and take time. Anyway, and it's important. Any way you all want to address it.
In terms of the commonality argument, Your Honor,
I've been asked to take a quick comfort break, Mr. Carlson. Can we do that? And then we
At the court's discretion,
we can complete this argument. So let me go ahead and do that.
This shit is crazy, yo.
Pain in the ass.
This shit serious, yo. Like this is live. It's right now. Like Thug are really in court right now. Like this shit really crazy, man. Like I seen them use lyrics. I seen them use certain lyrics. I'm telling you, I seen them use people's lyrics. They use people's lyrics. The judge in this case knows that's a major part of this case. Them lyrics. He know that a lot of shit that Thugger was saying was directed the tour bus situation, whether he had something to do with it or not. You know, everything I'm saying is allegedly, but everything he been accused of, it was rapped about. So that's the funny part. That's why the judge had to sit there and laugh for a minute. Like he cause like everything that's going on, supposedly, allegedly that's going on in this case. Allegedly that's going on in this case. They feeling it. They feeling the words. They feeling them words from words. They know the words. They know what them words mean. Like, look at it. Like, if you look at YFN Lucci case, he's not even pushing his case. Why? They so focused on Young Thug. That's the crazy part. So whether they beat Young Thug or not, whether they beat him or not, that's when they gonna try come up with Lucci case and towards the end of this. No. Why Lucci's still in there? He allegedly in there for pushing somebody out the car. Before I brought him to the hospital, y'all to try to put me on some Melly shit. Like, see how they got Melly in them? They said they was, main man Borland said he was in the drive-by shooting. Somebody slid up beside him and was shooting. Boom. They get locked up for that shit. So it's like, damn if you do, damn if you don't. That's what this case is like to me. Like Thugger and Melly, they join as the serious. Like Thugger couldn't even cop the fuck out. He couldn't even cop out at the beginning. He couldn't even cop out to a 15 or 30 or nothing, a 10 or 20 or nothing. It's like nigga, they cop out. Like he copping out to what he faced in life. So it's like it's crazy. That's why a nigga looking at it. That's why I thug it, and I'm probably looking at it like I'm not just gonna take no life. Like you just not just gonna hand it to me in my hand like here, thank you. No. Know what I'm saying? Sometimes you gotta rumble. That's what's going on in this case, man. You about to rumble, man. Like we still not even in a trial yet. Like this is crazy. Like Rollo home, he done got caught. He done got caught with all the gas and shit all over the plane and shit. Rollo come right home, diss this shit out, motherfucker. Yo got it, them niggas CMG. I know them niggas wasn't expecting that. I know they wasn't expecting that, gang. Gang. They wasn't expecting that, man. But this case about to resume, man. We waiting for the judge to come back on, You know how they do. Waiting for the judge to come back on. It took a little recess break. That's why I'm talking y'all motherfucking head off. But no, man, this case real. Like that, the judge don't want to let them. He don't want to let them bars go, them quotes go because he know that's the majority of the case. He know that. He know that one of them lyrics can land that nigga in jail. He know that. We just waiting on the judge to come back. They went on a recess break. It's live though. Don't think this is pre-recorded or nothing. This is live. Thugger and I'm in court right now. It's on a recess break. The judge about to wrap it up. But you know the lawyer Brian Still was going at him. The lawyer was going at him. He like, you charging my man with hearsay. You basically charged my man with hearsay. They called themselves a boss. They called themselves the. Why them niggas ain't locked up? What's the difference between me and them? That's how he looking at it. That's how the lawyer trying to paint the picture. What's the difference between my client and the rest of these rappers? Don't use these lyrics. These lyrics is just a form of expression of what's going on in the gutter. What's going on in the Grammy parts. It is a sticky situation. This joint live. Don't I know your patience is probably short, but no, they in court right now. Like this a whole live joint, like they in court right now. Young Thug lawyer was just getting at him. He was getting at the judge, basically telling him, "Yo, drop that. Don't let him use the lyrics." The judge, like, no, I got a lot of them. So he like, what about the First Amendment? He like, oh, it do, yeah, to some of it. The judge know that something in them quotes. Yeah, they had recess. They had recess break. Like if you rewind my shit back a little bit, you will see it and you'll hear it. You see the people moving. in court. Yeah. I ain't know that shit either. I'm like, damn. But no, it's privacy though. So it's a lot, it's a lot of shit that can happen. A lot of shit that can happen, safety reasons. Thugger got a lot of fucking money. Like this is like an OJ case. You know what I'm saying? This a big ass case. This joint really like an OJ case. Like damn. Here we go. We back on. Let's see what the judge gonna say. Let's get on. I feel like it can go either way. Yeah. That's why they so uptight on this case. I mean, that's why they so uptight on them lyrics. Like, if you heard of the boy AR from Philly, they use his lyrics. They use his lyrics to convict him. There was certain shit that he said that was allegedly. I'm still gonna use allegedly because he got found guilty, but he trying to get an appeal. But yeah, it's the same scenario. Only thing about it is Thugger been doing it longer. This shit go all the way back to 2010. So we talking 10 years of lyrics. Him beefing with Lucci, all that shit. They got all that. Him talking about shoot at your mama house, all that shit. Yeah, they roofed this shit out at in 45 years. They gave him 45 years. He already.
Is everybody back at this point in time?
All right.
Okay, all right. Thank you, sir. All right, Mr. Carlson, I'm giving you a little bit to think about, just in your concluding remarks or in addressing Mr. Steele's
Anything you about to say is used.
arguments.
Just a little evening homework, Your Honor.
Yes, sir.
May I proceed?
You may proceed, sir.
Your Honor, in terms of commonality in that position, there are only 2 points to make. The first is, what isn't common? Well, what isn't common around these dimensions is YSL. We're not seeing the term YSL appear all over the country in all sorts of different venues and in all sorts of different rap songs, gang rap songs. What we're seeing, Judge, in this case and what's before this court in the instant proceeding is whether or not the specific lyrics the case is presented and the ones that will present in trial pertain and relate to evidence relevant to mens rea and actus reus components of these charges. So it was interesting, and even looking at it, this is said by a lot of people, this is mentioned all the time. YSL isn't mentioned all the time across the country, but it is mentioned a lot in terms of forceful declarations of this gang's strength, this gang's behavior by these defendants, who now through their lawyers are attempting to mask that all and shield it from the application of the rules of evidence by claiming somehow it's art or common. And that gets to the next point, Your Honor. This didn't only apply to Mr. Steele's and doesn't only apply to Mr. Steele's point saying that this is somehow common. There were a legion of alternative explanations given this evening. Well, that's jury material, Judge. Is this art? Was I a aspiring rapper? I didn't really mean it. Those factors, Your Honor, are factors to be decided by the jury. Does this lyric, does the content of this lyric inform us something about whether or not this group constitutes an enterprise under Georgia law,
I'm telling the
whether or
truth.
not it constitutes a criminal street gang under Georgia law, whether or not it demonstrates association with either on the part of the defendant, whether it demonstrates the nature of either one, whether it goes to whether or not this individual committed one of the underlying offenses in this case, or whether he was just joking, or whether he just likes to pretend. Those are jury issues, Your Honor. They're not authorizations under Rule 403, much less the First Amendment, to exclude the evidence. And that gets to a point, Your Honor, about the First Amendment. We heard, and I recognize this is a large case, and I recognize there's a lot of paperwork, and I recognize that there has been stress and an incredible number of unique demands on every person, court personnel, lawyers alike involved in this case. But we heard it was only today when we received this case law and Carpenter gets singled out. Well, I'm looking at the state's first lyric brief, Your Honor. According to the stamp I have here, filed December 1st, 2022. Page 3. Relevant lyrics are admissible and do not offend the First Amendment. You know what case gets cited on page 5?
This case.
Or in there? Carpenter on page 4. Now, it's a block site from Carpenter. It's
This
not
shit
cherry-
crazy.
And again, Your Honor, this is what we were told was only seen today. So Carpenter's there at page 4, which circles back to the state's initial argument about volumes of material have been produced by the state on this issue, and the record will speak to whether or not there's been an equivalent supply of authority the other direction. But I'll read directly from the block site from Carpenter. Carpenter argues that his rap lyrics and music video were improperly admitted at trial in violation of Federal Rule of Evidence 403, as well as that the First Amendment protects his rap lyric as a form of artistic expression. The case, Your Honor, footnoted there at footnote 5 on page 4, again, December 1,
crazy.
2022. And of all the allegations faced by the state today, being able to move back in time wasn't one of them. Carpenter covers both issues. And it says here that it pertains back to the other Carpenter case, the earlier one, the one at 372 Fed Sub 3rd 74. Well, we have, go through the 403 and First Amendment. First, they address the 403 in Carpenter. Rap lyrics are properly admitted where they are relevant and their probative value is not substantially outweighed by the danger of unfair prejudice.
Who is
And then
Carpenter,
and then there are then there's another federal case cited for that. And a district court can thus admit them after conducting 403 balancing. Cite to another federal case. Next sentence.
We gotta
The
find
First
out who is
Amendment has
Carpenter.
no bars to the evidentiary admission of rap lyrics, whereas here the artistic expression is not itself the prescribed conduct. So I could continue reading, Your Honor, but I recognize the court's reviewed the briefing in this case. That is right there, over a year old, and somehow, and it's that this and other authority in this area was characterized as only appearing today. Now, Your Honor, that lets us know where we should go in terms of a First Amendment analysis here. The court performs that First Amendment analysis when it examines what use the lyric is being proposed for.
What he said.
That gets us back to the chart, Your Honor. Does the lyric form the corpus delicti of the crime? Is the speech what is being prosecuted? That's not the case here. And the cases we cited dealt with threats. A threat can be prosecuted for those words. But in this case, the speech is evidence of the crime rather than being the crime itself. Might go to mens rea, might go to actus reus, might go to both. And it might apply to building a racketeering enterprise. It might apply to building a gang enterprise. It might apply to association, to either, both. And again, it might prove what are the underlying crimes. So that First Amendment analysis that opposing counsel has been asking you to perform is exactly what the state has recommended. look at the use, and make the determination.
Right.
But there's nothing here that takes us into the area of the speech being the prescribed conduct. Now, going to some of the court's other issues, the foundations for, and again, opposing counsel, one of the lawyers here, and I don't want to name names, it's actually admissions are under 801D2. 801D1 it deals with something different. The factors that lead
This
to
shit
the
getting sticky.
introduction of an admission, a party admission or declaration against interest are well known. And who authored it is not one of the foundational factors. It might influence something like a 403 analysis, but in and of itself, it's not one of the listed factors there. But let's just take that argument lock, stock, and barrel for a second, Judge. And let's say somebody else wrote it. It was extreme. It was violent. It promoted the gang, and a YSL gang member said it. All right, now it's an adoptive admission. Just like in the Riccio case, Judge, we had earlier today, where the gang lyrics were posted by someone else who apparently changed them some and put them up on his own site. So again, at best, that authorship argument takes us to an adoptive admission, which is going to be admissible again, and for those who are co-conspirators, admissible as if they had said it through the co-conspirator exception.
Right.
And another factor, Your Honor, when it comes to First Amendment analysis,
That's crazy.
there was a string of cases that were gone through
Associated with these
by the
lyrics.
defense. Well, this isn't a First
Allegedly.
Amendment case, and it's in the PowerPoint. And this isn't a First Amendment case, and it's in the PowerPoint. We were down, I believe, to page 18 there, well past when the state was discussing First Amendment implications, and we were into actus reus, mens rea, and the various applications of the evidence rule. So those cases weren't presented in the First Amendment context. But yet that was, and again, recognize, Your Honor, there's been a lot of moving parts on this case, but I wanted to clarify that for the record. So we now look at the propensity issue, Your Honor. The introduction of what will wind up to be an incriminating statement in the form of an admission, one type or another, or declaration against interest, that is somehow relevant to a matter at issue in this case is not propensity evidence. We're not saying he did something bad before and therefore he is bad now. That's the forbidden inference under Rule 404. That's not what this is. It's we have things like me and my slimes above the law demonstrates that that YSL exists and there's a certain ethos there. That's a governing principle, Your Honor. It demonstrates that they're associated in fact in some way. So again, that's not to say that someone who's in a gang who thinks he's above law, that in and of itself, we're saying he did something bad and he did it again. That's just not a factor there. And even so, then the defense should have gone to every one of them and made an objection under 404 and challenged us to bring that into evidence under 418 or 404. And that's not where we are here. We are on a constitutional and pretrial 403 challenge to this evidence.
And the state did not give notice under 404B. The state did not give notice under 418. That is their burden. It's not my burden to object for that. They blew those statutes. They can't.
That shit crazy. That's all I can say, man.
And it's nice that Mr. Carlson popped it now, but he should know that it is all these deadlines are ready.
Well, now have you heard, Your Honor? A, no notice needed for intrinsic evidence. We've demonstrated how this is all intrinsic.
That's not 404B or 418. You just said 404B or 418. Intrinsic act. You don't need it.
No, you
That's
don't.
not what Mr. Carlson just said.
That's our point, Your Honor. They never made an objection that this was, they didn't bring the issue to you, Your
He
Honor.
been heard that.
What Mr. Carlson is saying is going back. state of Georgia cannot rely on 404B or
They been talking about these lyrics.
statute is supposed to do prior to trial, prior to the hearing. Sufficient time. They did neither. To say now it's intrinsic, that is not what Mr. Carlson said moments ago. That's what I said.
And they also blew their deadlines as far as identifying the lyrics that they tended to use. And then they're at the same time saying, well, we didn't object to these specific lyrics early enough. When they never told us until, what was it, November 6th?
Well,
This week?
Have you heard, Your Honor?
yes.
All right, Your Honor, they're making my point. What I said was, this is not propensity evidence. That's why we wouldn't have had to notice it that direction. Does it form intrinsic evidence? Of course it does.
They try to make it seem like this ain't the main part of the case,
Believed
but
any
it is.
lyric out there in the indictment or anywhere else should come through another route to file the appropriate objection. So, Judge, this isn't being offered for a propensity purpose. So, what we heard from the defense actually agrees with the state. We went to pains to demonstrate how it's intrinsic evidence. And again, for those guidepost cases, we noticed it's up to the objecting party to make a determination what they don't want in, especially when the evidence is relevant. That's Rule 402. So to say that somehow the state ought to, and again, these cases talk about that being overly burdensome on the government, go out and search and find certain matters that it believes it's going to bring in and believes somehow would be objectionable, identify it, put it out there before the defense, who's actually the one who should be making the objection to it, is really the opposite of where much of that material goes. However, my colleagues on this case actually did go through and go that extra mile and provide opposing counsel and the court with a list.
This
and then
DA
provide
crazy.
detailed information on how all of this integrates in the case through Deputy District Attorney Hilton today. So, Your Honor, in terms also of the Rodriguez issues, and I will point out for the court that the triangle diagram, as far as how 1615-4A operates, that was in Your Honor's materials in the that was in the PowerPoint, was designed by Mr. Floyd specifically for the argument in Rodriguez versus State. And the most compelling part of Rodriguez versus State is that the First Amendment does not protect association aimed at criminal activity. So, Your Honor, we go through those areas. We now get to 704B. And
What page is the triangle on? Just so I can
This DA going
Judge,
crazy.
my PowerPoint is printed off a little differently, Judge, but I might be able to find it.
They came back
20
prepared.
is what I have, Judge.
It's going to be slide 28, Your Honor. Okay.
I see it. Thank you, counsels. I see it.
And again, Your Honor, the First Amendment issues in that first brief go page 3, 4, 5, and Carpenter in there. And incidentally, Judge, on page 5, after Carpenter, there is a block site with multiple cases discussing introduction of rap music evidence, as it called in there, in cases, and again, discussing its admissibility. So
they watching our pages.
There, and actuality case law provided. Now let's talk about 704B, Your Honor. 704B does not prevent an expert witness from explaining what gang symbology means, what might in the gang content certain lyrics mean. It doesn't prevent that at all. What 704B expressly forbids is experts invading the province of the jury by stating the state of mind of a criminal defendant if that state of mind is an element of the crime in which they're accused. In other words, it's a much different question is, well, within the context of YSL, what does I've got bodies on bodies mean, according to your experience as a gang expert? Well, did the defendant act with criminal intent when he committed murder, in your experience? That's the forbidden inference in 704B. And even then, there are limitations. For instance, 704B does not prevent an expert from drawing conclusions about intent so long as the expert does not profess to know a defendant's criminal intent.
Wow.
So we see also Judge Glanville, Chief Judge Glanville, on the issue of, the court can probably notice here, the expert witnesses, if I may have one moment, Judge. Expert witnesses providing information along those lines. I'm going to read now just quickly from United States versus Smith. Apologies for bending forward, Your Honor. 919 Fed Third 825, 919 Fed Third 825.
This shit goes dark.
2019. And again, talking about an agent testifying about coded terms among drug users drug dealers as an expert. Now, there's another case here from the Ninth Circuit where there were some problems with the way the prosecution qualified the expert, but that's different than the context. That's United States versus Holguin, Holguin, 51 Fed 4, 841, 51 Fed 4, 841. That is a Ninth Circuit case from 2022. Again, talking about experts giving the meaning of gang terminology. So, once again, Your Honor, the position that's somehow barred by 704B is just a misreading of 704B, which is sometimes called the Hinckley Rule, related to the person involved in the attempted assassination of President Reagan. That's the period of time in which 704B came into being. So, Judge, now we take a look at several other issues that were raised. Let's just look a few times. Where is Delilah when it comes to, or Delia, when it comes to Johnny Cash? We didn't hear one thing from the defense that Johnny Cash was accused of killing that person. We don't know if there was even a murder. And in none of those cases where we had those supposed comparisons, did we have any mention of any motion from the state, motion for the defense, or ruling from the court on any of those issues. So again, those positions were of no moment. At best, they're alternative explanations, perhaps fodder for final argument, but not admissibility issues. The same goes, Your Honor, for some of the other areas that were covered. When we heard things like, this is all just fantasy. Your Honor,
Right.
someone could look at that indictment and see one thing for sure. That's not fantasy. People are dead, murdered, and a gang exists. Those aren't fantasies. This terminology here, again and again and again, that Deputy District Attorney Hilton and Special Assistant District Attorney Floyd went through, demonstrating the interconnections between these proclamations of violence and defiance and the crimes in this case. That's not fantasy, Your Honor. That is tragically real. And if the position is going to be taken at some point that somehow this is all just a form of artwork, again, as the cases have informed us again and again and again, that's jury material, not exclusionary statute material. So several other points, Your Honor. As to this, it was interesting, when we were speaking about Mr. Kendrick, the "for slimes I know I kill" line did not seem to be as much of a feature of the argument. That's definitive, that's forceful, but in terms of the song Dream, my colleagues had told me that the 2013 was a hypothetical. I'm looking to my left to make sure I'm correct on that. Was a typographical error. But regardless, and it's actually that 2015 date, I believe, is the correct one from that the court read, and that would be in our more current materials. That was repaired. But that gets to this date with regard to 403, Your Honor, and when did something happen? You know, all of that discussion really seemed to bypass that we've got a racketeering and gang case here. And this criminal organization has endured. So statements that are going to relate to some factor that's going to build a gang count or build an enterprise count, per the decision of the Supreme Court in Kemp when it comes to the co-conspirator hearsay exception, they're not timed out because of some constituent crime.
Hey.
Because they go to support the case of evidence leading to proof of the organization's existence, its nature, association with it, whether this crime represents participation in the organization. So that's not going to be part of the 403 analysis in the way that was conveyed, particularly in light of the other counts that are there. So in specific, the enterprise and gang counts. So this whole issue of threats, we're getting back a little bit into the court's First Amendment inquiry. YSL threatening to murder witnesses. YSL talking about, which is certainly threatening, murdering police in language that will be decoded in case. That's threatening.
Damn.
But it's not a threat that's being prosecuted for the words itself. It's proof of what YSL is, how it exists. And yes, the motives and states of mind that people who are going to associate with it, and whether or not that type of motive and that state of mind is going to make it more likely that they will associate with this criminal street gang, also known as racketeering enterprise. So it's again not a case where that threat itself or that threatening conduct is what's being prosecuted per se, as in a true threat case. The fact that they threaten people is demonstrative of the nature of the organization. Think about it, Your Honor, in a comparative circumstance of something like an admission by conduct. Somebody might flee the scene of might go running away from the murder. That's going to demonstrate consciousness of guilt of the murder.
Right.
But they're not being charged with running away from the murder. The evidence still comes in to demonstrate the underlying offense. So, Your Honor, I want to take one more matter on. And again, I want to stress that point. The threats are proof of the crime here. The threatening conduct and misconduct is proof of the crime here. The threat does not constitute the crime here.
Proof.
Those aren't the charges. And Judge, there was a lot of talk about no other type of expression getting prosecuted this way. And I want to direct the court to our first supplemental lyric brief, which I believe was filed in late 2022 or early 2023. And I'm going to take the court to page 2 of that brief, where there is a block cite from the federal court of case from the Fifth Circuit of the United States versus Cannon, 750 Fed 3rd 492. 750 Fed 3rd 492. That's a 2014 case from the Fifth Circuit dealing with a hate crime prosecution. Convictions were affirmed. Again, Wisconsin versus Mitchell, major Supreme Court case, gets quoted once more. You've seen it, Your Honor. The Supreme Court has made clear that the First Amendment does not prohibit the evidentiary use of speech to establish the elements of a crime or to prove motive or intent. Then the court goes on. Moreover, our sister circuits have considered this issue, have all allowed speech-based evidence to support a finding that a crime was motivated by racial hatred. And there they cite a case that was in our materials, United States versus Magleby, Magleby, 241 Fed 3rd 1306, 10th Circuit 2001. Evidence that the defendant listened to CD with racist lyrics was relevant to establishing that the defendant targeted the victims because of their race.
Could even
So
bring
again,
up
Your
the
Honor,
joint,
as
the
we've
cop,
seen,
the Tupac
and
joint.
we haven't drawn a moral equivalency between the YSL rap, gang lyrics, and evidence of racist lyrics in hate crimes cases. But as we've said before, there's a legal equivalency there in terms of the rules of admissibility. So once again, Your Honor, the gang lyric evidence in this case is proof of actus reus and mens rea, not only of the underlying offenses, but of the racketeering and gang charges. The state is offering these for the evidentiary purposes, and those evidentiary purposes alone. So we will reiterate, Your Honor, our respectful request that the court grant our motion for conditional admissibility
For the
and
lyrics.
introduction of the lyrics we have set forth today under the controlling rules, the ones that we will bring to the court as the trial proceeds, and to deny the defense's motion.
Dang.
Thank you.
All right, counsels. I'm going to take the matter under advisement overnight. It's almost 9 o'clock. It's been well argued, well briefed. And what I'll do is counsels, we're supposed to start tomorrow morning at 9:30 with
Oh.
your firearms and other particular individuals that indicated to me tomorrow. What I'll do is I'll take the first part when we all come at 9:30, and I'll issue my ruling, and I'll tell whoever the prevailing party is to prepare a suitable order. So if you all could come back tomorrow morning for 9:30, I'll have a decision at that point in time. Okay. All right. So, State, Ms. Hilton and Ms. Love, are you all otherwise prepared for the firearms examiners?
This
Mr.
shit crazy.
Marini,
This
and,
case is crazy.
microanalysis, gun residue, the late print examiner for tomorrow.
Yeah, yes, I see my investigator coming up.
Okay, all right. Well, I'll take those up as soon as we finish this. I make this ruling, and then I'll cover as well. I have taken a look at the jail call between the three individuals to finish ruling upon that issue in terms of residual hearsay. Ms. Love, I was not, as much as I tried, I was not able to, until later today, I got our tech guy to load the evidence viewer on my computer. So until I have a look at that, I'll go ahead and I'll continue to defer that issue. But I've read the transcripts of both witness A and B. I'd like to take a look at just finished taking a look at that. And then, Ms. Hilton, I know we need to complete the other extra argument on 418. So I'm, depending upon what where we are tomorrow, but my goal will be for us to make a ruling on this issue. So Mr. Carlson, if I could ask you and Mr. Floyd to come back in the morning, that would be definitely appreciative. And I'll make that ruling in first, and then I'll release it to you, and we can go on to some other things we have. Okay?
Understood, Your Honor. 9:30 tomorrow, then?
9:30.
Yes, Your Honor.
All right.
Tomorrow is ruling on this.
This is crazy. I hope it don't take all day just to come back and say he using the
Everybody, please
lyrics.
be quiet. All right. You didn't hear what I said, Mr. Steele?
I did. I got confused. Are we doing the residual? I know it's Mr. Matthews, but residual hearsay. And then I heard you say something about 418. That's what I heard.
No, I was stating that I listened to the tape, the jail call. So I know I need to rule on them as of yet. as of they're outstanding. I also need to rule on the witness A and witness B. In terms of whether or not they fall within 801 D2E, D2E one
Sure.
issues. Those are the two. I need to look at I need to look at the tapes themselves. I wasn't able to get the viewer installed until today. The state's proprietary evidence reviewer. I have read the transcripts, so I still need to complete those. And then the 418, I have to complete the other acts. Ms. Hilton needs to complete that.
So they behind.
Okay.
That's tomorrow. That's what I'm asking.
I don't know if it's going to be tomorrow or not.
Okay.
It just depends.
Okay.
I'm just telling you it's outstanding. I may pull the trigger on those tomorrow, but I know they're outstanding, and I just need to make a ruling on those.
Okay. Thank you, sir.
All right.
Your Honor, we haven't heard argument on the residual for the court.
On what?
We have not heard, the court has not heard argument as to the residual hearsay for the court to be able to make the ruling on that. The court has heard the jail call, but the court has not heard argument from both sides on that issue.
Right. We're gonna do it
You
tomorrow.
got 15 minutes tomorrow if I decide to rule it. So you need to be prepared, okay?
Thank you, Your Honor.
All right. All right. We're in recess. See y'all in the morning, okay?
Thank you, sir.
Okay.
See, man, that shit really got serious, man. That shit really got serious, man. I don't know what Young Thug and I'm gonna do. I don't know what they gonna do. But that shit ain't there. That ain't there. Nah, bro, it ain't there. It ain't there. It ain't there, y'all. But let me know in the comment section what y'all think. I'm out.